it's Connecticut attorney Ryan McKeen here. Today I'm going to talk to you a little bit about jury selection in Connecticut from a trial lawyer's perspective. Now, if there's anything I love about the practice of law, it is jury selection. Connecticut is unique in the way we pick a jury. I've talked to lawyers from all over the country, even internationally, and Connecticut does jury selection different than any other place that I know. Connecticut's jury selection by constitution is individual jury selection. You may hear it referred to as individual voir dire. Now, what individual voir dire means is that every juror is questioned individually, outside the presence of other jurors, and often outside the presence of a judge, and possibly outside the presence of a judge and clerk. Every court does it differently. Sometimes the clerk is in the room for jury selection. Many times a clerk is not in the room for jury selection. So let's start from the beginning of the journey of a juror. And I have been a juror, so I have gone through this process. Generally, when you get summoned for jury selection, you're going to have to fill out some basic information about yourself, and that information is going to be given to the lawyers who are hearing the case and the clerk. And the reason why the lawyers get this information is so they can identify, maybe they know you. And I have a funny story about this. One day I was driving home from work, and I called my parents, as I often do, and I was talking to my dad. And my dad said, "You know what? I have jury selection tomorrow." And I said, "You know what? I'm picking a jury in Hartford tomorrow." And sure enough, my dad was in my jury pool. And that rendered him unable to serve, obviously. It would be, probably pretty great for me if my dad were on my jury. Though maybe not. He's a fair-minded individual and can be a tough critic. But anyhow, my dad would not obviously be eligible to serve on my jury. And all of our communities are pretty small, so maybe you had somebody who was your teacher, a friend, a coworker, a colleague, and that's just so we can know about you, and maybe you have a common name, and so we know maybe some more demographic information. Maybe we know that, oh, this is a different John Smith than the John Smith that we went to high school with, right? So you get your list, and you're going to go into a jury room. You're going to sit down. You're going to watch a video. The video is going to explain your obligations. A judge will generally come in and say a few words about the process, and from there, what's going to happen is jurors are going to be pooled together. In some courtrooms, some jurors may go to a criminal court, some may go to the civil court, some may go to this trial, some may go to that trial. And so you're going to be probably taken from this larger room, if necessary, and brought into a smaller room or to a courthouse or to a courtroom itself, and you're going to sit there. And what's going to happen is the attorneys are going to introduce their case. They're going to say just a few words about the case. So you may say, for example, this is a car accident that occurred in Enfield, Connecticut at the intersection of Hazard Avenue and Elm Street on December 18th, 2022. And you may put that out there so that the jury has some idea as to what the case is. So that you're not sitting in on a corporate bankruptcy case, or that you're not sitting in on a commercial case. You're going to know it's a car accident. You're also going to hear from some of the witnesses that are involved. So that way, if we are, and some of the witnesses, the witness list may be long. And the reason why is, for example, we may have to read off a list of treaters who treated our client. So if you have the same doctor, that may be a bias. You may have an opinion of the doctor, good or bad, and everybody is entitled to an impartial jury. So we're trying to see if there's any conflicts. You're also going to get read a lengthy list of names of people who work at the firm. Again, we're trying to see if you know somebody at the firm, because the whole point of the process is to try to get a verdict that is fair. Parties have generally litigated cases for years. They've been unable to come to some resolution despite pressures from maybe the clients or maybe the courts to try to resolve it, but some cases are unresolvable. And when they're unresolvable, we turn to the community to render a just result. And a just result is one where the jurors are deciding on the evidence that is in the case and nothing else. Not their opinion that the doctor is the greatest doctor, not their opinion that the doctor was rude to them, but really just what is in the record on the case. And so after you hear this, and the jury clerk may ask, do you know anybody? Do you recognize any of these names? And they're going to try to figure out if there are any conflicts. Lawyers are generally going to go off to the side. They're going to get a list of prospective jurors that are in this pool, and they're going to start looking through them, again, checking conflicts. So if you've gone to jury selection, you may have to get there for 8:30, 9 in the morning, whatever it says on your notice. We may not start calling jurors as lawyers until 11:30, 11 o'clock, 12, somewhere in that range, because the introductory process takes so long. So generally speaking, jury selection is either going to be in an empty courtroom or it's going to be in a conference room. That all depends on the court. So don't be surprised if you're sitting at a conference table. And who might be in that room? Well, the plaintiff's lawyer, the person bringing the case, their attorney is going to be there. The defense lawyers are going to be there representing the defendant. You may see the plaintiff, the person who was hurt in a personal injury case there. You may see the defendant in the jury room as well. And the lawyers should introduce themselves. They'll introduce their clients if their clients are there. And you'll be asked questions. Now, as lawyers, there are some basic rules. We alternate. So, the first jury person, maybe the plaintiff asks, the second first questions first, and then the second jury person, the defendant goes, and you sort of rotate between each other to ask questions. And so lawyers have broad leeway in asking questions. What are some questions that you may be asked? You may be asked your opinions about lawyers. You may be asked if you've ever been involved in a court case. And the whole point of all of these questions isn't to be invasive, isn't to pry into your life, but it's to get a sense of who you are and whether or not you are a fit for a jury and or appropriate for this jury. For one case, you may be a juror who's able to be unbiased and perfect for it. In another case, you may not. We've had examples of that. Maybe in the Hartford area, we see a lot of insurance people not automatically disqualifying, but if they do claims management, well, they're going to naturally bring their experience as claims managers into the jury room, and that's not okay, all right? And there also may be people out there who have some opinions that render them unable to follow the law. You may have people out there who say, every plaintiff who brings a lawsuit is a scam artist looking to get money, looking to hit the lottery, and I would never give any plaintiff $1. Well, that's not okay. That opinion may be okay in your personal life, but in a jury box, it's unfair to the parties who are seeking a fair and impartial juror. And on the flip side, you may get a juror who says, I believe everybody who gets hurt in a car accident should get $10 million. Well, that's not going to be fair to the defendant, and so we're looking for neutral parties. What we're, ideally as lawyers, we hope for jurors that are going to be favorable to our side for one reason or another. But practically, what we can most practically hope for are jurors who are going to listen, who are going to engage, who are going to be fair and unbiased, and really listen and decide based upon the evidence. Now, by being unbiased, I mean everybody brings their biases to anything that they do, but I mean that they're not, my example of an insurance adjuster in a claims case, they're going to bring a lot of their personal experience that goes beyond the evidence in the case. So you're going to be asked, you're going to be asked questions about yourself, maybe about your background. You may be asked about, some hypotheticals. Could you award money if you found this? You're not going to be asked about the facts of the case. That is inappropriate. Your personal life is not going to be pried into. I've spent many, many days in jury selection and never seen a lawyer pry into somebody's personal life, but they're just going to want to get a sense of, where you work, what you do, what you might do for fun, and a real idea as to who it is, because the case is really important to both parties, okay? And after you're asked questions, you're probably going to leave the room, and the lawyers are then going to talk. Now, for one reason or another, the lawyers may say that they may agree that something that was said that rendered the person ineligible for jury service, and they may strike that juror by agreement. Sometimes a judge may want to see the person, sometimes not. Sometimes the lawyers can't agree. One lawyer may say, look, I heard what this person said, but I don't think it renders them fair and impartial. And so at that point, a lawyer has to go and get a judge and have testimony brought on before the judge. You may have to go into a witness box, answer some questions. You may do it in judges' chambers, depending upon the courtroom. And we're trying to figure out if there's what's known as a for-cause challenge. A cause challenge, lawyers have unlimited cause challenges. We also have other kinds of challenges called preemptory challenges. We each get 4 preemptory challenges. Maybe if there are 2 separate defendants or 2 separate plaintiffs by 2 separate lawyers, there could be as many as 8 preemptory challenges, but there's at least 4. And those are challenges that are basically, for any reason at all, we can say, look, maybe this person is, technically meets it, but I think that they're unfavorable, and I'm going to remove them from the jury. But you only get 4 of those, so as a lawyer, you've got to be very careful as to who you're using those preemptory strikes on, or you can really mess up your case because you have that juror who we call the death juror to the case, and you can't get them out because you have no preemptory. So the sort of force is to seat people who are reasonable, because you can always do worse, and maybe a judge lets somebody out or maybe they don't. So some of the decision as to whether or not you're sat on a jury is done outside of your knowledge. You may just get the clerk may tell you that you've been seated, or the clerk may say that you have been excused, or the judge may say it, or the lawyers may say it. So that's the process of what happens, from a lawyer's perspective. And again, nobody wants to waste anybody's time. Nobody wants to have jurors that are going to be unfair to their case. Very few cases ever get to trial. And I'm going to say that there are no minor trials, because even if somebody may be hurt, maybe they didn't die, they didn't have to have surgery, but it can have a significant impact on their life. And if it's a trial, you as a lawyer owe it to your clients to make sure that the process is fair and impartial. So if you're, in sort of conclusion, look, if you're going to jury duty, first of all, I'm kind of jealous. I would love to sit on a jury if I could. Bring some books, bring some reading materials, bring an extra charger on your phone. I see people bring their laptops when they're waiting around and doing some work, whatever it is. So bring some things to amuse yourself. Always check the court rules regarding snacks and beverages. Those can change from place to place. Some courts will allow you to have some things in. Some jury rooms have some refrigerators, some don't. It should be on your judicial notice. But be thinking about where you might want to have lunch. What happens if you're hungry? What if there is no vending machine? Courts mostly have vending machines, but you never know. You don't want to take that for granted. Make sure ask about water bottles. That becomes a whole thing. Some courts let you have them in, some don't. Some are like the airport where they have to be emptied. So just in general, if you're going to call ahead, those are some good things to ask about the food, the beverage, what you can bring in. But when you're being questioned, you're just going to be by yourself. It's going to be informal. It should be it should be not feel like an interrogation. I would say generally, most people are questioned for anywhere from 10 minutes to a half hour, which would either be like 5 to 15 minutes per lawyer. Sometimes it goes longer than that if there's something that the lawyers don't understand about your background, about what you're saying, and about whether or not you're a fit. Again, it's not, if you're not chosen to serve, it doesn't mean anything. It's not like you weren't picked for the dodgeball team in elementary school. It just means that for this case, there may be something that may cause you to bring outside knowledge into the courtroom in a way that it does not follow the law. So that's an overview of jury selection in Connecticut and jury duty in Connecticut from a Connecticut trial attorney.